Hi, this is Chris McKaylee, and today's video podcast is on enrolled bill reports and gubernatorial action. As hopefully folks know, once an enrolled bill reaches the governor's desk for final action, enrolled bill reports, or EBRs, are produced for the governor and senior staff to consider the merits of a bill pending on the governor's desk. An enrolled bill, of course, is the final version of the bill that has passed both houses of the legislature, has gone through the engrossing and enrolling process, and has been presented to the governor and is pending final action. California's governor, as you may recall, has three choices with that bill that's reached his or her desk: sign the bill to make it a statute, veto the bill to prevent it from becoming a statute, or allowing the bill to become law without the governor's signature. The enrolled bill report, again, most often referred to as an EBR, is an analysis of the bill with information and a recommendation for final action, sign or veto. Agencies, departments, the Department of Finance, even the Legislative Counsel's office can provide these EBRs to the governor. And generally, the EBR remains confidential as a private communication with the governor, although some are available after the governor's tenure when those documents are provided to the state archives overseen by the Secretary of State. EBRs are prepared for bills, but not for constitutional amendments or resolutions, because, of course, these measures are not acted upon by the governor. Generally, there are three EBRs prepared for the governor's review: one from the Department of Finance, one from the relevant agency that has jurisdiction over the subject matter of the bill, and the department or board or commission that oversees that program, and the Legislative Council where necessary. The DOF prepares an EBR that primarily focuses on the estimated fiscal impact of the bill. And one important aspect of this fiscal analysis is whether the fiscal impact has been accounted for in the state budget. If it is not, a common rule of thumb is that DOF will usually oppose that bill and seek a veto on fiscal grounds, because the measure could result in additional unbudgeted revenue. Now, although the DOF's focus is primarily fiscal in nature, they do often raise policy concerns with a bill as well in that EBR. In terms of bill analyses versus EBRs, the general rule is for bills that were opposed during the legislative process, DOF's EBR generally recommends a veto. If, on the other hand, the DOF supported the bill during the legislative process, then its recommendation is usually to sign. But of course, DOF can take a neutral position and not recommend either a signature or veto. In addition, the relevant state agency makes a recommendation in its EBR submitted to the governor's office. In most circumstances, the department or the board or commission or council that has jurisdiction over a bill's subject matter, or of course the department that's directly or indirectly impacted by a bill's provisions, will submit that EBR. And naturally, the governor and the governor's staff will want to understand the regulator's point of view and how the particular bill could impact their program, the program administration, etc. However, there's another level of review, often before the governor's office receives the EBR. The EBR goes to the agency that oversees that department, board, commission, etc. So, for example, the Department of Conservation or CAL FIRE might prepare an EBR with its analysis and recommendation, and then forwards it on to the resources agency. And then it's the agency that decides the final recommendation to be made to the governor's office in the EBR. The Legislative Counsel's office also often prepares an EBR because they have to, among other things, identify any conflicts between the bills. For example, bills that passed the legislature in the same session that attempt to amend the same code section or code sections. This is done to ensure that the later enacted statutes, or bills in this case, do not chapter out earlier statutes that were enacted. So, for example, the Legislative Counsel's EBR may recommend the order in which the governor signs one or more bills. In addition, a copy of the Legislative Council's analysis is delivered to the bill's author, which is required by the joint rules of the Assembly and Senate. The EBR by Legislative Council doesn't make a policy or fiscal recommendation on the bill. Instead, it's to address the ministerial aspects of the bill for the benefit of the governor and the governor's staff. Finally, the governor's bill file normally contains letters from outside parties that are urging the governor to sign or veto the particular bill. These are often submitted by interest groups that had either supported or opposed the bill as that measure traveled through the legislative process. And now their letters of support naturally become letters requesting the governor's signature, while letters of opposition are turned into letters requesting the governor to veto the particular bill. Oftentimes, and hopefully in all cases, the bill's author sends a letter requesting the governor's signature on the bill, and the governor's staff may have their own notes from meetings, phone calls, or other interactions that they've had with proponents and opponents of the bill. Some governor staff have included the floor analysis in the bill file, or other bill analyses and studies or other information that might be helpful. Of course, the final version of the bill is usually at the top of the file so that the governor can actually review and read the measure. So all of these documents become part of the governor's bill file and on the bills. And obviously all of this information is for the governor and the governor's senior staff to have all the information that they need in order to make the best educated decision about whether to sign or veto the bill on the governor's desk. Depending on the bill and how the particular governor approaches decisions on pending legislation, these EBRs often play a very critical role in whether the bill gets signed or vetoed in the end.